welcome to this media briefing of the National Press Club. A special welcome to those colleagues that are following us online. And then to our speakers, Ngwaku Mohlaloga, the Deputy Chair of the Association for the Protection of Road Accident Victims, APRAV, and Peter de Bruin, the chairperson. Guys, when we pour petrol, each of us contribute to this fund that is supposed to have hundreds of billions of rands in their purse. We know there have been several problems with the fund. It has been in the news for all the wrong reasons. Today we are looking forward. What next? And I'm going to hand over to Ngwako, and they will tell us what they have in mind. Thank you.
Good morning, and thank you for the introduction, Antoinette. My name is Ngwako Mohlaloga. As Antoinette has already explained, we are coming from APRAV. The full name is the Association for the Protection of Road Accident Victims. We established in 2014 precisely as a response to the REPS. I think I need to point that out and make it very clear. Government around 2010, 2012 proposed to change the system through which they compensate victims of road crashes. And in doing that, they proposed this thing that they call the REPS, the full name being the Road Accident Benefit Scheme. So it's a scheme of some sort where government then proposed to compensate victims of road crashes on the basis of defined benefits. So they class the benefits of the system of compensation. Now what we did was to carefully examine these REPS and determine the kind of benefit or impact it will have on the victims. That was back in 2014. I remember my very first view after listening to people that have gone through the bill at that particular time. I regarded this as a sunken bill, and I can explain why. My view was that people were sitting having coffee in Sandton and came up with a scheme and thought it will work for South Africa. Now, for someone like me who comes from a village, I've got both my parents there who are still there. I then quickly realized that these REPS won't benefit my parents, who are South Africans, and in the event of an accident, they deserve to be compensated like all other South Africans. That's when then we came together and said, we need to do something about this bill. And we've been at the forefront of fighting that. The fight since 2014 made several trips to Parliament to make sure that we help members of Parliament to understand the impact of the REPS becoming a law. This took many flights to Cape Town, to Parliament. It took many trips on the road to all over South Africa to go meet with various members of the Portfolio Committee on Transport and indeed other members of Parliament. Our approach has always been very simple. We engage members of Parliament. We're not operating across party political lines. We have been very clear on that one. We're not fighting a political battle. Ours is to fight for the victims of road crashes and to make sure that whatever outcome that Parliament is going to produce is going to be favorable to victims of road crashes. Now, understand that once you are involved in a motor vehicle accident, already you're a victim. You have been victimized by a road crash. Now, we then realize that then we become victimized for the second time by the system, by the RAF system. And the reps would have been far more devastating for various other reasons we are going to outline here today. Now, government at that particular time, the CEO then would then say the benefits are going to be the same as in SASSA, so defined benefits. For this kind of an accident, this is how much we pay you. So that's how they define the benefits. But they're forgetting that no two accidents are the same, or no two injuries are the same. So, and people's circumstances differ. And that would not have been taken into consideration. So that was our biggest problem. The biggest issue with the REPS is that it's a no-fault system. What that means is that while the current system is saying, let's look at who is at fault and then determine if we are going to pay or not, the REPS is saying a criminal who is running away from the police and then causes an accident in which the criminal is then gets injured is going to be compensated. And I'm sure we can all agree that that system can therefore not work. The biggest other problem with the REPS is that it's entirely based on rehabilitation. And for rehabilitation to work, the government system that has been proposed and the president has recently signed it into law is the NHI. So the REPS in its entirety is based on the NHI being fully operational. We all know where the NHI is. I'll give you an example of where I come from. In Bochum, the nearest hospital is plus minus 47 kilometers away from where I stay, from where my parents are. Now, if I get involved in an accident there, chances are very fat. In fact, all the time I've been there, I've never seen an ambulance. So if I get involved in an accident, and in the whole village there are 3 or 4 people that are having cars, and most of the time without fuel, it'll be very slim for me to get to a hospital for treatment. Now, for rehabilitation to work, you need to be treated quickly after the accident, stabilized. That increases the chances of rehabilitation. Without that, you can't be fully rehabilitated. Now, that's the basis of the REPS. Now, given the current circumstances in our country, we then realized that the REPS is not going to work. We then took it upon ourselves to, as I've said before, make several trips to Parliament to empower members of Parliament about the pitfalls and the shortfalls of the REPS. Safe to say that before the 2019 elections, then Parliament rejected the REPS after us having made convincing arguments against the REPS. Now, we are here today because in the endeavor by the Department of Transport and the Ministry of Transport through the mouth of the Minister of Transport, Mr. Baba Chrissy, in an endeavor to fix whatever challenge there may be in the REF, the minister then suggests that she wants to reintroduce the REPS in Parliament. And we have again reached out to the minister, written several letters to her to indicate to her why the REPS can't work. And this is part of a process, I suppose, to educate the public of South Africa, and we are very grateful and thankful to the NPC for having given us this opportunity. Speak to the public and say, if the REPS is what government thinks is a solution, sitting here today, we can safely say government needs to reconsider. The REPS is not an answer. It is never going to work. Part of the documents we have prepared for circulation to the minister and are supposedly made available to the media is that the REPS is going to create secondary victims. More and more people are going to be victimized. We don't see this as a solution, but as APRAV, as we've always been saying, we are more than willing and are able and capable of making suggestions that we believe can work. for the betterment of the system. In 2022, in October, the Portfolio Committee on Transport, where the laws are being made, invited us to solicit, views, ideas on what we believe can be solutions. We have made an in-depth presentation to the Portfolio Committee on the various solutions that we've been working on, having engaged experts in the field, doctors, professors, academics. We have assisted us to come up with what we believe are workable solutions. We are of the firm view and of the belief that the current system actually is functional. What needs to happen is that the fund needs to get its house in order. They just need to implement the current act as it is, and as a result of which there might not be no need, there might not be a need, let me rephrase, for a change that as proposed and suggested by the Minister of Transport. If the RAF gets its house in order and focus on its core mandate, which is to investigate, adjudicate, and compensate victims of road crashes, we believe that the system can work only if the fund focuses on what it is doing. Perhaps my last comment as I was doing this intro will be to say we need to bring to the attention of the public and government that introducing the REPS does not mean you are scrapping the current system. It will still be, ring-fenced. It will still be running. The contingent liability that government has, the contingent RAF liability that government has, does not automatically disappear because there's now a new system. What is going to happen is going to have two systems that are running concurrently, because we must still pay what is the liability that is there currently. Now, our calculations, and we can make that available, are that if you introduce the REPS, which is a no-fault system, it is going to add 60% cost to adjudicate or to run the new system. Now, our country as things stand cannot afford that, but I need to state that ours is for the victims. We are advocating for a system that is going to favor the victims, and that is a hill we are willing to die on. Going forward, we're going to engage. We'll keep on engaging Parliament. We'll keep on engaging the Ministry of Transport. We'll keep on engaging the public, and through platforms like this, we are hoping that at some point sanity is going to prevail, and that government is going to engage its key stakeholders to make sure that whatever system they come up with is fair, equitable, justifiable, and key constitutional. Thank you very much, and thank you for the opportunity. Peter?
Good morning, everyone. I'd like to focus on 4 core issues. The most important 2, why RABs failed 3 times in Parliament, being presented by the then majority government ANC, and why their own bill couldn't pass 3 times in Parliament, which, by the fact, made parliamentary history. Not been done before, and it's not been done since. We have to understand why. And it seems Minister Creasy has been living somewhere else, because she is simply ignoring those fundamental reasons. My second point will be, I'll explain to you the 10 reasons why. And again, now, I don't want to be critical towards the minister, who's done a lot of good work in a lot of areas, but with all respect, excluding the RAF. There are 10 things that Minister Creasy must look at and then tell the public if she is still wanting and promoting RABs as a solution. The other 2 things I'd like to focus on is, what is the bigger context and just what happened? The bigger context is the following. This system is in existence for 70 years, and it's being tempered by litigation. Every nook and cranny, every word, every section of this act has been vetted by the courts. It's one of the most vetted third-party systems in the world. That's step one. Step two, it became too expensive with the previous insurance-based premium, and therefore the RAF was created 25, 30 years ago. You should also understand, and this is a critical technical constitutional issue in this regard. 30 years ago, the government acknowledged that South Africa's realities mean that there's a lot of poor people, a lot of not well-educated people, and a lot of unemployed people. Figures there average in South Africa, but critical. Group between 16 and 35, the unemployment is 45%. So they then created a system to say, we are not going to allow individuals in a poor country to sue one another like it would be in the US or Europe. We, the government, is going to step into the shoes of the wrongdoer. And then if you are injured in a crash and you are not able to work, we will then facilitate a process whereby you could get compensation. And South Africa's system has been touted as one of the best in the world. So remember, government took away human rights from you and in its place gave you the road accident fund. What happened then is this system was developed when there were 2.5 million cars on the road. There are now in excess of 11 million cars on the road. So obviously this system is not custom made anymore. It's become cumbersome, it's become expensive, it's become too time consuming. But the answer to what was proposed in 2002 by a national investigation led by Judge Kathy Satchwell was there's a number of things that can happen, but more research is needed. More work is needed, more analysis is needed. And this led to the current last 10 years, where for the last 10 years, there were practical solutions on the table, but for some reason, there were no political appetite for these. And that resulted in the current 10-point plan that was submitted to Portfolio Committee in Transport, 22 October 2022. That would address almost every single current critical matter that's there. But for some reason, a bill, and these are the 10 points why it's not ever going to succeed. And we implore Minister Creasy not to waste another 3, 4, 5 years and add to the public's already waiting period of 5 to 8 years to try and promote something that's failed before in her own government. Read why it didn't pass. And those reasons are, it's unaffordable, unconstitutional, not implementable, not planned, not researched, and most important, will further harm the poor, the less educated, and even the rich and the educated. All of them would have the same harm. At that point, it would have added a 60% cost to the current 40 billion rand fuel levy bill. But understand what I'm saying. For 5 to 8 years, the RAF would have to continue functioning. So for 5 to 8 years, because that's the backlog, 750,000 claims are behind currently. That would take 5 to 8 years to run down. So for 5 to 8 years, the current fuel levy is wrapped up by law. Fuel levy is 30 billion a year for 5 to 6 years will be used by law. Can't change. Not even the Constitutional Court can change it because it's a creature of statute. If it's in there, it's in there. But what is not explained to the public by the then Department of Transport promulgating this, that means for 5 to 8 years, another 30 billion rand plus 60% would be needed to run RAVs. Treasury in Parliament publicly said there's no money, and that made the House of Cards fall down, and the RABS was withdrawn by the ANC members of the Portfolio Committee on Transport themselves, no other party. Why? Minister Creasy, please talk to them and find out. Nothing has changed. It's even worse now. The backlogs. The RAF used to settle about 60 cases per employee 10 years ago. They now settle 4. In RAPS, currently in the RAF, they settle about 30,000 claims out of 100,000. So despite the outgoing CEO Collins Letsuhalo's claims to fame and performance and excellence and paying him multi-million rand bonuses and driving around with fancy cars, I don't want to go into that story, 30% of all claims used to be 60 per capita. It's now 4 per capita that they settle. So the backlogs are worse than ever. RABS is fully dependable, as my colleague and deputy chair indicated, cannot work if NHI is not fully implemented. Now, NHI may be on the president's desk and had a signature on it, but NHI has zero chance of working in South Africa even over the next 10 years. One, there's no infrastructure, there's not enough medical people, there's not enough funding, there's no infrastructure created for this, etc. Then this whole issue of no fault being a silver bullet is a total myth. Even we say everyone has a claim, you will still have to show that you've been in an accident. You will still have to show that you've had injuries. Like now, there are 4 requirements in the RAF Act. Those are 2 of them. The only difference in RABS, you will have 0 assistance from government. Now, government acknowledges, the RAF acknowledges. I want to go back to my friend of 25 years, growing up in a village, Bochum, in Limpopo. This means in RABS the following. If you are in Bochum and you are injured, RABS would require you to submit your claim electronically via email. There's no paper submission. So Nwaku's elderly parents would have to, some way or another, get to a computer, fill in a form that at that point was 8 pages, and I had difficulty to try and complete it. Then it must be submitted by email. Then you send it to the RABS office. After that, Nwaku's parents wait 180 days or 60 days in the beginning to hear if your claim has been approved. Then you get an SMS to say yes or no. If it's no, you resubmit all of it electronically. Keep in mind, 47 kilometers away from the only medical facility. There's no Wi-Fi. I can tell you there's very few smartphones in the beautiful village of Bochum, where I've been to many times. Now they have to resubmit it to the same people, judge and jury in their own case. So this agency now rejected you, you go to the same people who rejected you, and 60 days later, you get another SMS to say you've been declined. That's it. Your common law, constitutional right to ask, to sue, to go back is eliminated in this process. They are judge and jury in their own selves. Obviously, that's not real in South Africa. If you also take into account about 69% of road crash victims, in terms of the 100,000 average a year, comes from rural, fairly low educated, fairly low income groups. So the mere process to apply and submit a claim in RABS is likely going to exclude 50 to 60% of all people. Now, how can government in RABS tout this as a pro-poor bill The reason they call it a pro-poor bill because it's a very beautiful political tagline for election purposes. But what is absolutely almost criminal is that they do not explain the truth to the public. That 40% might submit a claim. Now, if you then are one of the 40% and you've managed to submit that claim, then they're going to say, all right, it's administrative clerical people mostly are going to look at injuries. You've had 2 severe leg fractures. They didn't heal properly. You've had secondary infections and you've lost your leg. So I'm a laborer on a mine and I don't have a leg. That's the end of your job. Why? 2, there's tens of thousands of able-bodied health workers that will take your job immediately. A mine cannot have a person with injuries working there because it's causing a risk to that person and other miners. So now, a person with a clerical background looks you up and down, see you hopping along, and decides, I think you deserve X rand. That's the first thing. Then a person that's not legally trained, also administrative, will engage and make a legal contract on your payment. Let's say that happens, which is absolutely not doable. Then they are going to agree to pay you only for the next 15 years. Only the next 15 years. So if you're 20 when this happens, at the age of 35, it ceases. They tell you, thank you, go home, be sick, be poor, and likely die. This is what the system is going to do. Minister Creasy must answer how this will work. Explain to us. I think the problem is Minister Creasy must change her advisors and must read the letters that's sent to her, because I think this is at the crux of the problem. I have a high regard for her, but she's absolutely ill-informed of this. Now, you get your claim. I'm the lucky ones of the 40. I have a claim now. Now they're going to say, pay you payments annually for 15 years. Currently, the RAF processes about 30,000 claims a year. They make 2 payments, normally a capital payment, the largest sum, and then they pay costs and what's associated with that a bit later in a secondary payment. That results then in 60,000 transactions a year. In RABs, that will increase to 1.5 million payments a year. Their backlog is 5 to 8 years. How will this work? How are they going to do this? So don't tell us RABs and payments. Explain to us how this broken administrative system, who can't cope with 60,000 payments, are now miraculously going to cope with 1.5 million payments. Then it's not stopping there. Then if you are Nwaku's family in Bochum, they're going to ask you every 6 months to go for a clinic for a checkup that they can see you still deserve the payment. If you miss it once, maybe you'll get a free pass. And if you miss it a second time, they're going to say you are not interested, you are not cooperating with the system, we are cutting your benefits. How on earth can the Minister of Transport, the Director General of Transport, and the powers that be in Parliament think this is pro-poor? It's not pro-poor, it's we don't care for the poor. For what reasons, I don't know. We have to ask the political powers that be and the ministry how they want to do this. So now you can get your benefit cut quite easily. Administrative people will do legal and financial type of work.
Medical as well.
Medical. Second last thing is the moral issue. This is a country where violence against women, rapes, domestic violence is absolutely rife and one of the worst in the world. No one disputes that. Our honored president is the same one saying these things. So what will rapes do? A rapist would rape a girl be chased away and drive away and be chased by the police is in a road crash, that rapist will have the same right to claim as any other person. How morally on earth is that defendable in South Africa? These are the reasons. If these things are counted and fixed, like right bodily integrity, right to access to courts, right to representation, right to equal treatment, right to a safe environment. If Minister Creasy manages a way to fix these things and address these 10 issues, RABS can work. Only then RABS can work. And we have no qualm. The system must get better. It's like having an old Nissan bakkie carting 1,000 tons of mine ore away from a mine site. You can do it. You can, but it's going to take you a very long time, and you're going to break down a lot of bakkies in the process. RABS must change. We have been advocated that at the top of our lungs since 2014. But it must be constitutional. It must be affordable. It must be to the benefit of the people of South Africa. It must be researched. It must be planned. It must be done in consultation. There must be stakeholder knowledge. It can't be done behind closed doors with a tagline. This is going to be pro-poor and kick out the pariahs in the industry. All of that is political smoke and mirrors and behind the door political nonsense. There must be change. There's a 10-point plan that will start addressing immediate problems. It would, in the next 6 months, start to fix many a thing. For example, create capacity immediately, add to claims handlers, even if they get insourced many of the unemployed accountants and lawyers that's in the marketplace. Train them, create a settlement hub, which is the intention of the Act. Settle. You can accelerate things immediately. Over time, create regional settlement hubs. Talk to the Department of Justice and create a new division in the High Court, similar to the Labor Court, on a High Court level. Specialized third-party law division, where you have judges doing this primarily. This would also lead to a process where the court rolls now have 80% plus RAF cases on it. That would remove them, and if the RAF start doing their job again, like they used to do 10 years ago, where only about 5% of cases went to court, and it was a short list of complicated, difficult, contested cases that should go to court, as is meant by the law and in common law. What happened now, the RAF 10 years ago stopped doing their work for not well thought through reasons, but to try and run the system down, which is still seemingly the outgoing CEO's intention until recently. Therefore, 80% of the 100,000 claims must go to court, because the RAF touches nothing if you don't have a court date. So you have to go through a legal process. Why then are attorneys accused of being the bad people? Yes, every industry has a few bad apples. Teachers, ministers, politicians, professional people, lawyers. There's always a small percentage doing wrong things. They are being governed. There's a heck of a lot of governance around attorneys in this country. But if the 10 cases, that's the bad apples, like the 10 cases in police, like the 10 cases under educators, are blown up sky high, it creates a wrong impression that that's the whole industry. It's not true. The RAF causes litigation by not doing their work. So what happens now? 80% of these cases go to court. Court rolls are absolutely overloaded. The judges are not coping. The judges are just not able to cope with the volume of claims. Therefore, if you now submit a claim to the courts, your first court date from now would be in 2030, 2031. That is not justice. That is not access to the courts. That is not equal treatment. Those things must be fixed, but it's caused by the RAF. 80% of the cases would go to court. Only of that 80% cases go to court, about 2% goes on trial. Why? When it's on the steps of the court, or the morning of the court, or the day before, then the RAF all of a sudden makes some sort of a suggestion in terms of settlement. 95% of that 80% then settles, but they forced the applicant to have attorneys to drive this. Otherwise, they just ignore you. Then they don't contest, so they had no seriousness to do this. Then it settles as it should have settled in terms of the act, but on the steps of the court, therefore now accruing a 6 billion rand legal bill for which the legal fraternity are being blamed for. If we think that Donald Trump has invented alternative realities, it's not true. It was invented by the RAF years ago, because the reality and what they spent 2 million rand a month on marketing was just to have created this absolute absurd bubble, which the Scopa investigation into the RAF finally made it burst, and the things being said here are the things that will come out. I conclude just with context. And this is a plea and an offer of assistance to the Department of Transport, to the Portfolio Committee on Transport, to the Deputy Minister and Honourable Minister Barbara Creecy. We don't have all the answers, but we have for a decade analysed, researched, investigated every nook of cranny of the good, the bad and the ugly of the RAF, with experts, professional bodies like the Orthopaedic Association of South Africa, with the Medico Legal Association of South Africa, in a solutions process spanning 2.5 years. And our 10-point plan was the result of that. It's well thought through. It takes the realities into account. It balances curbing costs, protecting the rights of victims. And the outcome of this plan would be that we honor the Constitution and not undermine it like RAPs will do. We keep the benefits to the public of South Africa as protected by law, saying you must receive reasonable compensation based on your work to make up for what you suffered for the accident. It would also create jobs. It would also protect jobs. It would re-solidify the court's operational process by removing a lot of the undue pressure on the courts. Barbara Creecy needs to do two things. She needs to please listen to the realities and the advice around RAPs. If she read, and I don't want to just talk about our civil society organization, a non-profit looking at human rights of road crash victims, if she reads 4 of our letters and she would stand up and explain how RAPs would work in that context, we would support RAPs. If she fixes these things, we'll support it. But we cannot support things that's unconstitutional. Also, this process cannot be haphazard. This process needs to be open, needs to be talked about, and let's not waste 5 more years. And I can assure you, if the RAPs as it was put forward since 2014 and 2019, I don't want to be arrogant and I don't want to sound contrite, but we will stop this bill again, like we did in 2019. We want to work together with the minister. We want to share our research. We are open. The industry is ready. The legal fraternity is ready. But if you keep on being an unwilling participant to solutions, only one thing is left. You fight for survival. And just the irony is the medical experts and the lawyers involved in this process fight not only for the survival of their businesses, which is their right in terms of the constitution of this country, but they primarily fight for the right of the persons that's injured. Issue here is this can be, lastly, a bottomless pit of complexity, further political meandering, and ultimately it will not stand the test of time. Minister Creasy, let's not waste that, and let's start with one input on a well-thought bunch of solutions. And we add stakeholders and very well-informed, educated people involving the whole industry. And let's quickly get to short-term solutions, saving the RAF, getting it back to basis. Then start fixing the bigger things into the future, which would also have to include some form of law review. Let's focus on settling claims and moving forward, and not fight a fight that was lost 3 times in 2019 again. Our focus, we are getting away from the legalities. We've had to battle unlawful things for 10 years. We could have, 10 years, helped with solutions. And if this bill is going to go forward, we unfortunately will have to keep on fighting for 5 years and then say, let's fix this. Thank you.
Thank you, Peter. There's quite obviously a lot that can be said about the reps. Remember, we've been at it. It's now 11 years. And we've been at it for that long. We've been very consistent. Even after the rep has been rejected by Parliament, we kept on knocking on the doors of the Department of Transport and Parliament to make sure that we are availing ourselves to them with the knowledge that we have, to make sure that at the end of the day, whatever system they come up with, as I've said, is favorable to the victims. Now, we are willing to take questions. If you have a question, you can give us just give us your name and the name of your media house, and the online questions as well. We can take them. Antoinette?
Anybody has a question?
France, and then Nobile. Can I just repeat the questions for those online if you didn't hear? The questions were, whose interests is this organization serving? How are you related to the legal profession? And how will you prevent the bill from passing? Thank you.
Is that the only question?
Yeah, we're only taking one.
Thanks, Franz. Whose interest are we serving? If you look at our name, the Association for the Protection of Road Accident Victims, so it's in the interest of the victim. It's as simple as that. What is our relationship with the legal fraternity? We've got a very good relationship with the legal fraternity, because in this country, if you've got a dispute with your neighbor, the one person you run to is a lawyer. If your rights have in any way been infringed, for you to be able to enforce your rights, you need a lawyer. We also believe that if you, for an example, let me give you a simple example. As we were fighting the reps between 2014 and 2019, one of the members of Parliament who engaged had a family member of his who was a victim of a road crash. He was a member of Parliament. He realized that without a lawyer, he himself is unable to help a family member of his. So indeed, we have forged a very good relationship with legal fraternity to make sure that the victims of road crashes are being are being assisted, because the system in itself is litigious. So I personally can't go to court and represent myself. And if you look at the fact that it's poor people in the most that are getting injured, and if you look at the amount of money you need to carry the claim process from claiming until the day you get paid, the lawyers are normally covering the cost. Without them, in this country, no victim is going to be compensated, because nobody's got the money to run through pay for the doctors and get medical records, and to simply make sure that they run down the system until they're getting paid. Can I request Peter to respond to the last one? How will you stop the bill, Peter?
Just to add to the Deputy Chair's comments, APRAV focuses on the constitutional rights of road crash users and victims, firstly. Secondly, we are not an organization with individual members like others which have 2 and 3 million members and they contribute. We represent pockets of industries. The Orthopedic Association of South Africa would give us inputs. The legal fraternity would give us inputs. The medical fraternity, the service providers like emergency services, hospitals that must save your life in the golden hour. So there's nothing untoward APRAV focusing on all the components of this industry, which involves doctors, lawyers, and many others. It would be naive and incomplete if attorneys were not part of the focus and part of what we do. So this created narrative that attorneys are the boogeyman is absolute nonsense. If an attorney is not pre-funding about 100,000 rand for your claim, is not transporting you to and from a police station to go and find your hospital records and your accident records, and transport you 4 or 5 times up to get to medical records, I can tell you now, 80% of all claims in this country will fail because this is government's job. Attorneys in this case, doing part of government's pre-funding, is actually stepping in to government. Then if they claim that money back, they are stealing money. It's absolutely an irresponsible and a really obscene positioning of the truth that is presented as not the truth. How will we do this in Parliament? Remember, Parliament is the House of the people. The 400 elected MPs represent all of us sitting here, 100,000 accident victims a year, and 45, 50 million people. They are not meant to work behind closed doors. In fact, it's unconstitutional. And let me remind you, a committee like SCOPA, Transport Committee, Finance Committee, is mere a smaller subset of Parliament. They have a delegation. If we see Department of Transport and we present to them, we are presenting to Parliament. It's just a subcommittee of Parliament. The legal standing of a portfolio committee is exactly the same as the legal standing of Parliament. That's why the process is what we will do like we did in 2014. And that's what we only ask for. Even if it's RAPs, we just ask the minister, go through the parliamentary, legislative, constitutional process. We will then find you there and you will find us there. But hopefully this is a sensible act where we can support it. Firstly, you need a cabinet decision. Yes, we need RAPs. It's not been done yet. 2, you need the portfolio committee on transport to accept a motion that this needs to be done. Then you publish a white paper and you send it out for industry comment. After you've amalgamated that, which never happened before, after you've amalgamated that, you amend the bill. Then you publish it for comment right through South Africa. And you have 3 constitutional choices here, a Section 75, Section 76, or a Section 77 bill. That depends, is there money matters involved, is there national interest involved, then they decide that. Then they put it out to all provinces. So they take this bill to all provinces, get a venue, get people to comment, then come back, then collate it, and then formalize the final draft bill. Then the Portfolio Committee on Transport goes through that bill line by line by line, and Portfolio Committee members keep on being made up by the Government National Unity and other members, line by line debate and argue that. Then, if that is done, it's published in the Government Gazette for a final reading in Parliament. Then it's raised in Parliament as a bill to be voted on, and a majority passes it. After that, undergoes one or two other legal scrutinies by the State Attorney's Office, then it lands on the President's desk. That's the process. In that process, there's 10 places where we will interact as our duty and is as provided by law. Now, what happened? Just to explain, RABS, Whitefell. They went out to the provinces, but they don't declare the venue. You get there, they say it's venue A at the hall. Then you get to the hall, no, there's nothing. They say, no, it's down the road. Down the road, you find some or other obscure little venue. So they changed the venue. Now, keep in mind, people doesn't have cars, or you need to take public transport there or walk by foot. You want to go and participate. We are fortunate. We ask, we drive there. You get there. When you get to the door, they hand you an 80-page English document of the bill. Now, first time. So now I have an English 80-page document, and I have 90 minutes to give comment. We will be at every one of those sessions, and we will make sure that people are informed beforehand, even if we camp there for a month before. And when they go in there, they will be informed what this is about. So we will, and that's our only focus, all involved in this broad arena, which involves more or less 1 million people a year. An industry that's direct fuel levy cost is about 40 billion rand a year, but the economic impact is about 200 billion rand a year. So in this 10-step process, except for cabinet, because we can't do anything there, but once it's in a portfolio committee, it's our right to go there. It's our right. We can't participate. We are not elected officials, but we can send the chair briefings before. We can share information before. They are MPs. Nothing precludes us from talking to them. MPs are there for the public. We'll talk to them. As my colleague indicated, since 2014, we've been talking to all political parties. So don't make this out as, for example, a DA thing or a minority party thing. We have engaged every single party, and every single party participated, and that's why in 2019 it failed. And this is what we'll do. These 10-step processes will be there every step of the way to fight the things that is in RABS. And if it's a sensible system, we will be there fighting to get it passed. Now, the minister must decide which one of the two she wants APRAV to do.
Thank you so much. Lorraine, you have a question?
Okay, for our online colleagues, the question is, how does the association assist victims that have lodged claims through attorneys but have been waiting for a decade or even longer than that?
Do you want to take that, Peter?
Yes, please. I can say that we've created a helpline, and we can maybe share that email address. We get a lot of queries similar to those almost daily. The first thing we do is just ask for a short list of bits of information. When was the accident, etc. Then we look at what's been submitted, whether there's been a direct claim to the RAF or whether you went through an attorney, because then we need to establish who is the responsible party, RAF or an attorney. If we can't find where that claim is at that point, we then have someone check the mandate. And if the mandate was with the RAF, a recommendation is if the RAF took 8 years and did nothing, maybe you should try the other route, and that's get representation. If you had representation and that's seemingly also not doing the job, we advise you to change that representation. But what we also do, there's also a lot of misconception about claims. For example, if you had an accident, you have to claim within 3 years. That's the law. So if you didn't claim in the 3 years, by law, your claim has lapsed. But it seems like in your case, if within that 3 years you started engaging with the RAF and or an attorney, the time delay is not disqualifying that claim. But those are the types of things we advise on these things, and we get a big stream of these and other complaints. And just by the way, that same line also attracts a lot of whistleblowing from within the RAF in terms of things, and we simply pass it on to the chairperson of SCOPA.
We had a question.
Perhaps
Sorry.
I can also add to the response by the chairman and say that the court rolls are currently extremely congested, and that then makes it very difficult for even lawyers to help their victims to get a court date. The RAF has put in layers and layers, compliance layers above and over the Act, the current RAF Act, to make sure that they frustrate victims from accessing the system. Bear in mind that if you don't have a court order, you cannot enforce, you cannot force the RAF to pay you, even if you've quantified sort of the amount that we believe is due to you. So you need a court order. So the court rolls are currently extremely congested. So even if you've got a very good lawyer, if today you comply with all the requirements of the RAF Act and the illegal board notice that has been imposed by the RAF currently, you are likely to get your court date in 2031 today. So, and that is something that the public out there are not aware of, that the courts are, as we speak today, causing even more harm to victims of road crashes. There are much bigger issues that we are going to be looking into. Today's subject is the RAPs, but the courts are also not helping the victims of the current of road crash. Of road crashes. They simply don't want to entertain. They simply don't want to make sure that victims are given a fair hearing, given justice, and then getting court date. So that I think I thought I had to add to that. Thanks, Antoinette.
Question here in front.
We have a question here.
That have been taken by the ministry, the suspension of the 2 executives, and as well as the dissolution of the board. And then regarding your characterization as an organization, I find it extremely debatable. How is APRAV a pro-poor organization when, based on your own explanation, you consist of industry bodies, which then suggests that this is an elitist entity? Do you have a single ordinary car accident victim that is part of this initiative? And Mr. Mhlalowa, consistently when we interview the CEO, he refers to an experience when he first joined the RAF where he was approached by yourself on behalf of a large medical aid scheme that is known. I'm sure you would have seen him making that allegation that you had sought to convince the ref to settle a liability that was at the time you were estimating it at about 250 billion as part of a discount offer by this big medical aid scheme. But then he says, according to him, upon verification, he finds that actually this liability does not even exist. So having to take this discount offer would have amounted to the ref being scammed.
I'm sorry, I'm going to stop you there. That seems to be a very specific
I suggest you
incident.
take it up with the panel member afterwards. But I'm going to, I'm not doing that, because we are specifically here to talk about the bill that is coming before Parliament. You can take that up with him afterwards, but I'm going to allow the question about the membership of the organization.
Yeah. I
Well,
think
Peter will respond to that question. Safe to say that I'm very happy to respond to all your questions after here. I'll make myself available.
I think, as I explained already, APRAV is a national coordinating human rights organization. So we involve key parties in the RAF environment. We don't have individual members, not even one doctor or one attorney or one member of the public. But to go back to your point, in 2019, we attended 9 provincial sessions with the public all over South Africa, big places, small places, where we sat with the public like this. We asked questions and we fielded questions with and for the public. So we have had many weeks of interaction with the public, whether they are members or not. That was the only way we could have meaningfully participated in the 10-point process of lawmaking in South Africa, where civil society plays an active role. And that's all we want to do. So do we have members, thousands? No, we are not OTA. They have a different model and people pay subscription. That's not how we work. We focus on the issue in Parliament. We're a human rights body looking at constitutional issues for road crash victims. And then we participate in the parliamentary process, where there's lots of interaction, also with the public. And then we put forward proposals, and they either like it or they don't, and we participate like anyone else. But there is massive campaigns. I've just mentioned now, we have a hotline where public can contact us, like the question from your colleague before, where we help and assist. We have whistleblowers where we pass the information on. So I don't see how that is not involving the public.
Before I take my last question, may I just ask, can you pinpoint for us the unconstitutionality of the bill, please?
Yes, there's a number of unconstitutionalities. Common law and the Constitution says we all have to have access to the courts. RABs will eliminate that. Constitution says you have the right to representation. RABs would eliminate that. Constitution says we all are guaranteed bodily integrity. RABs would eliminate that for many reasons, that an admin person is looking at Nwaku's amputated leg and making a decision. That is not, I think, what the Constitution means. Furthermore, Constitution says everyone has equal rights to equal support. Will not happen. Last thing is funding. To deny road crash victims their constitutional right, as taken up by the road accident RAF, would mean that what they used to get and what's been customized through law and court cases would now totally be diluted, and for totally unconstitutional reasons. So there are 6 or 7 main constitutional issues with the RABs. If those are fixed, maybe our opinion on RABs would fix and change.
Thank you. Last question, sir.
Up to my question, but before I go to my follow-up question. It's so unfortunate that you, Chair, suppressed Mr. Maholero's question because these are allegations that were made public. And
I
it will
know,
be in the
Frans, I'm
public
sorry, I'm
interest.
not going to
It
allow
will be
you
in
to
the
give a
public
speech.
interest.
We have a specific topic today and we
But
speak
this
to
is
the
a media
topic,
briefing, so
and that
far as
is
we
why I am the
understand.
chair.
But it will be
And
in
I'm
the-
sorry, you can keep on talking, but I'll talk over you. I won't allow
But
that.
what I'm saying
I'm
is,
sorry,
it
I'm
will be in
not
the
going
public
to allow
interest
it, Frans.
for him.
I'm not
I'm not going to allow it.
I'm not
I'm not going to allow it. 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 I'm sorry, Frans. Will you please remove yourself from this briefing? Will you please remove yourself from this briefing? Frans, will you please remove yourself from this briefing? Frans, will you please remove yourself from this briefing? Frans, will you please remove yourself from the briefing? Can we please cut we are closing this media briefing.